Students, case number 8 of 2021, that is scheduled for it. Classes for the next.
I am for the meeting in this matter. My colleague Mr. Musili has taken his position and serving in the office of the President of Advocates. Your Honor, this matter is to mention today to confirm the enforcement of the warrant of arrest that were issued by this in the court, dated the 30th of April 2024. Your Honor, the defendant was arrested yesterday and availed to Nakuru later in the evening after judicial time. Your Honor, the warrant of arrest related to disobedience of the lawful decree that was issued by this honorable court on the 2nd of June 2022. Issued on the 2nd of June 2022. To date, Your Honor, there is no compliance with the said decree of the court. Upon being notified that the defendant was availed to Nakuru yesterday, upon being notified that the defendant had been availed at Nakuru Central Police Station yesterday, and visited the said station, Your Honor, with an aim of seeing whether we will be able to agree with the defendant on compliance with the decree of the court. Unfortunately, Your Honor, our talks bore no fruit. And as such, I will be moving the court as appropriate for today upon hearing my colleague on whether there is any compliance thus far.
Your Honor, we have heard the sentiments of my senior. I understand there was a decree that was issued on 2nd June 2022, which you are not aware of. Therefore, Your Honor, before I proceed to address the court on my side, I would wish that this being a post-judgment matter, and we have been unable to find the previous advocate who was on record for the defendant, the court should grant us leave so that we can be able to address the court on the issues of the warrants to come on record properly for the defendant. Your Honor, this is a post-judgment. So, I understand there was another advocate. I heard my senior saying, Mr. Mutai. Yes, that one you are not aware. So, Your Honor, if you are granted the same, then I'll address the court as follows. Your Honor, we were just instructed yesterday, and as you understand, Mr. Collins was arrested partly for disobeying court summons. Your Honor, Mr. Collins has never been served with any summons. He has never been informed or notified that there are warrants of arrest against him. Your Honor, this is a children's matter, whereby Mr. Collins seems to have been ordered to pay child support. Your Honor, we are unclear of the amounts being claimed, having just been instructed. yesterday night. Your Honor, unconfirmed reports indicate that the amounts are in the millions of shillings. Your Honor, our client has no source of income and could definitely not have been in contempt of court for simply being a pauper. Your Honor, his inability to pay millions of shillings is not intentional, but actual inability. Your Honor, the presence of our client in court is subsequent to a warrant, which he was never notified, never issued with a notice to show cause, just found himself having been arrested. Your Honor, we will be making applications and pray for time to do so, to set aside all adverse orders and to review the rulings of the court in regard to the financial ability of Mr. Collins Moi. Your Honor, it is in the public domain that Mr. Collins Moi is embroiled in succession matters in regard to his father's estate, the late Jonathan Moi, and his grandfather, the late President of the Republic of Kenya, Daniel Toroitich arap Moi, which matters are yet to be concluded, Your Honor. Your Honor, in fact, the plaintiff in this matter is also a party to those proceedings and is very much aware of Mr. Collins' financial situation. Therefore, Your Honor, our client's failure to honor the decree that was issued is not because he has refused to do so. Your Honor, you can even look at my client. Where does he have those millions that is being claimed in this court? That is your Honor. Yes. Assess.
Yes, Lord.
Even the appearance, Your Honor. If you have millions, there's a way you don't come to court, Your Honor. Before I address on the issue of the arrest, I'll rest my case there.
Yes, Your Honor, on the issue of the instructions, I had raised that issue in the morning, and this court gave directions that this being a children's matter, strict adherence to the rule of law, or rather the procedure of law, is waived, and directed my colleague to file his appointment, which he has done, and I'm not delivering that issue because the court already delivered itself. Your Honor, on the issue of summons, had my colleague taken some little time to familiarize with the record of the courts, he would have noted that on the 26th of January 2024, my erstwhile colleague, Mr. Mongeri, had filed an application dated the 24th of January 2024. An application of contempt in nature and pursuant, dated the 24th of January 2024. I as well colleague Mr. Mungeri filed an application of the nature of contempt. And this court, upon hearing that application and duly satisfying itself that the same had been served upon the predecessor counsel, Mr. Mutai Kikemoi and company advocates, issued warrants of arrest against the defendant herein. The record will bear as witness that there is an affidavit of service confirming service upon the same advocates, and as such, there was no legal obligation upon the plaintiff to serve the defendant in person. Regardless, upon issuance of the warrants of arrest, the defendant was notified, and again the court record will bear as witness that we have mentioned this matter countless number of times unsuccessfully, owing to the cat and mouse games that were played by the defendant. In fact, to Your Honor, there is a report that we filed in court in our last court attendance confirming private investigations that have been done unsuccessfully upon the defendant, and requested the court to grant us an extension of time to liaise with the office of the OCS Nakuru for enforcement of the decree and orders of the courts. It is pursuant to those warrants, Your Honor, that the defendant is present in court. Now, my colleague has presented a sorry state of affairs as far as the defendant is concerned and his financial capability. However, Your Honor, I submit that there is nothing new that has been presented before this honorable court. That information is contained in a replying affidavit that was filed before this honorable court, sworn by the defendant on the 7th of September 2021, sworn, Your Honor, on the 7th of September 2021 in opposition to an application, a notice of motion application interim for provision of maintenance. Further, Your Honor, the proceedings of these honorable courts will bear as witness that the defendant was heard on merit. Again, he rehashed what he has mentioned to court this morning. And the predecessor courts, upon hearing the defendant and the plaintiff, arrived at a judgment that was delivered on the 2nd of June 2022. On the 2nd of June 2022. It is therefore, Your Honor, reasonably expected that upon delivery of that judgment, the defendant would have appraised the courts as to what he has done in compliance with the said judgment of the courts. Your Honor, from the submission of counsel, other than submitting on evasive grounds, there is nothing tangible that has been placed before this honorable court and or even orally submitted as to what the defendant has done in compliance with the judgment of the courts. For records purposes, the defendant was supposed to provide for education and all educational related expenses of the minors. He was to provide a medical cover for the children and was equally to share in the cost of the entertainment together with the plaintiff. Regrettably, Your Honor, there is no material that has been placed before this honorable court to show an iota of compliance. Sadly and regrettably, while he takes his responsibility casually, the minors are the ones that are getting affected. Your Honor, the firstborn child is now in Form 1 or Grade 8 at Mustard Seed School. That child, the firstborn, is Grade 8, sorry, Year 8 at Mustard Seed International School. Having completed his KCPE last year, was unable to join high school on account of lack of fees. My client reached out to the defendant to ensure placement of this child in a high school. The defendant made a promise that he would ensure the children, or rather the firstborn, was enrolled at Kabarak High School. Regrettably, that was not to be, and that minor stayed at home for 2 terms. It is only this 3rd term that my client was able to raise some funds in the best interest of this child and enroll the child in that school. Your Honor, I submit there is willful and deliberate disobedience of these court orders that were issued by these honorable courts by the defendant. I have availed the current payment receipts for Mustard Seed. Confirming the minors' enrollment this year and of this term. And thus, Your Honor, I pray, seeing that there is no proposal whatsoever that has come from the defendant that he be committed to civil jail, actually sit to jail, until such a time when he will be ready to purge the contents of these honorable courts. That's all, Your Honor. Sorry, Your Honor, I forgot to mention that my colleague alluded to a succession course that is pending at Nairobi. However, Your Honor, that is an independent court that is handling the matter. This honorable court has not been supplied with an order of stay of proceedings of this children's course. And as such, there is nothing that stops these honorable courts from dealing with this matter as it deems appropriate. Lastly, Your Honor, The decree of this Honorable Court having been issued 2 years ago, actually over 2 years ago, the defendant has not moved the High Court for review, has not moved the High Court for appeal, and all these Honorable Courts for review of the said orders. They therefore remain valid orders of the courts, enforceable, and execution, Your Honor, of decrees of court and orders of court is a lawful process. There is nothing illegal in enforcement of the orders of the court as we have done, and I therefore urge the court to rise to the occasion and commit the defendant to civil jail until such a time when he purges the contempt of court. That is all.
Your Honor, what I can say is this. We have just come on record in this matter. So a lot of things that have been said, we could not have known them because it's only in the morning. Actually, yesterday night at 10, I was called, given instructions to come to court. Now, even if I would have looked at the file, I need to get copies of the same, enable us to make the appropriate applications, which could not have been done given the time. Secondly, Your Honor, on the issue of the defendant being committed to civil jail, I don't know how that relates to the purpose, because even if we commit him to civil jail, how will he pay? Yes, he will stay there for 1 month to get him out. Then we come back here again. Your Honor, what we are praying is this. We'll be given time to put in our appropriate applications, and then my senior can serve us with the applications as we make our photocopies so that we can know how to respond. And Your Honor, further, the mistakes of an advocate, honestly, should not be visited on an innocent litigant. Your Honor, we pray that we look at the best interests of the children, even if we commit him. Maybe if we talk to him now that he's outside, we can see how to work it out. But if he's committed to civil jail, I don't know how. And Your Honor, the warrants, I believe, were for the attendance of the defendant in court, and the plaintiff is also in court, being represented. So I believe those warrants will now lapse. We put in our application, we respond to the application, and then if we fail, now we commit him to civil jail. That would be all, Your Honor. Your Honor, we also be filing a affidavit of means because I've seen that issue has been raised.
That or one and second, and the aspect is of disobedience of the
Yes, Your Honor, the issue is, that's what I'm saying, if he was aware of all this, I believe he'd have reacted on time. Because you see, if you are saying Mr. Mongeri served Mr. Mutai and he never responded, then it means there's an issue. That is all, Your Honor.
That's what.
Well, I'll consider the application and the response in form of submissions by parties. I'll give a substantive ruling at 4 p.m. today.